Hello everyone, welcome to my YouTube channel which is explore yourselves, banking and general knowledge, etc. Your next promotion is not just a step up in your career, it's a step closer to your dreams, your respect and your financial growth. The bank promotion exams 2026-2027 are your golden opportunity and I am here to make you sure you grab it with both hands. In this journey, we'll learn smart strategies, master important topics, and tackle questions just like the exam demands. Remember, success does not come to those who wait, it comes to those who prepare. So let's start today. Prepare smartly and make your promotion in 2026-2027 a reality. Welcome to part 13 of my Path to the Corner Office 2026-2027 series, where we break down real bank promotion exam questions and give you clear, practical sample answers to help you climb the career ladder faster. Subject: Deposit Products, Miscellaneous Deposit. Question: The bank's partnership letter Form L438 is preferred over inspecting the partnership deed because option A, it is legally superior to the deed in all respects. Option B, it relies on the implied authority of partners under the Indian Partnership Act 1932, avoiding restrictive clause complications from the deed. Option C, it removes the need for KYC documentations. Option D, it automatically registers the firm. Correct answer is option B. It relies on the implied authority of partners under the Indian Partnership Act 1932, avoiding restrictive clause complications from the deed. Question: Under Mohammedan law, if the father of a minor is alive, an account operated singly by the mother requires option A, no documentation, since mother is automatically a natural guardian. Option B, a letter of consent signed by the father using a specimen format with natural deleted before guardian for the mother. Option C, a court order appointing the mother as guardian. Option D, the account cannot be opened under any circumstances. Correct answer is option B. A letter of consent signed by the father using a specimen format with natural deleted before guardian for the mother. Question: Under Mohammedan law, even after the father's death, who is considered the natural guardian? Option A. The mother automatically becomes the natural guardian. Option B. The mother is not considered the natural guardian. She can act only as guardian, not natural guardian, typically with a stamped indemnity. Option C. The eldest son automatically becomes guardian. Option D. A court-appointed guardian is mandatory in every such case. Correct answer is option B. The mother is not considered the natural guardian. She can act only as guardian, not natural guardian, typically with a stamped indemnity. Question: For Hindu minors under the Hindu Minority and Guardianship Act 1956, the natural guardian of a minor married girl is option A the father, option B the mother, option C the husband, option D a court-appointed guardian. Correct answer is option C, the husband. Question: A minor may be permitted to operate a deposit account alone without a guardian once he or she attains what minimum age subject to bank practice. Option A 12 years, option B 10 years, option C 15 years, option D 16 years. Correct answer is option B 10 years. Question: Where an account is opened and operated upon by the minor alone, aged 10 or more, the maximum balance permissible at any time in a savings bank account is option A rupees 10,000, option B rupees 25,000, option C rupees 50,000, option D no upper limit at all. Correct answer is option B rupees 25,000. Question. In a joint account of a minor below 10 years with a major relative operated as former survivor, the account opening card option A must be at the specimen signature of both major and minor from inception. Option B bears the major specimen signature. The minor specimen signature is obtained only upon completing age 10. Cannot Option C cannot be opened until the minor reaches 10 years of age. Option D requires minor's thumb impression instead of guard signature. Correct answer is option B. Bears the major specimen signature. The minor specimen signature is obtained only upon completing age 10. Question. In a joint account of a major and the major decreased, minor is still below 10, the account. Option A is frozen until the minor turns 18. Option B can be operated by the natural guardian of the minor until the minor attains age 10, after which it is operated by the minor himself. Option C is closed immediately and the balance transferred to sundry deposits. Option D continues to be operated by the deceased major's legal heirs. Correct answer is option B. Can be operated by the natural guardian of the minor until the minor attains age 10, after which it is operated by the minor himself. Question. For a public limited company, the certificate that must be inspected in addition to the certificate of incorporation before opening an account is option A. Certificate of commencement of business. Option B. Certificate of good standing. Option C. Certificate of solvency. Option D. Certificate of registration under the Shops and Establishment Act. Correct answer is option A. Certificate of commencement of business. Question. The certificate of commencement of business is not required in the case of option A public limited company only. Option B, a private limited company or a company limited by guarantee. Option C, any company incorporated after 2015. Option D, a company with paid up capital above rupees 1 crore. The answer is option B, a private limited company or a company limited by guarantee. Question. An omnibus resolution for opening a company's current account at an outstation branch is acceptable provided that it option A is a circular resolution passed without a formal board meeting. Option B is passed at a meeting of the board of directors and mentions officials by designations rather than by name. Option C is signed only by the managing director without board approval. Option D did not be certified by the company's secretary. Correct answer is option B. Is passed at a meeting of the board of directors and mentions officials by designations rather than by name. Question. Under Section 147 1C of the Companies Act 1956, the proper form of signature on a company's check requires option A only the name of the company printed, option B the name of the company followed by the signature of the authorized signatory with designations, option C the company's common seal alone, option D the signature of any employee of the company regardless of authority. Correct answer is option B, the name of the company followed by the signature of the authorized signatory with designation. Question. Upon receipt of a court's winding up order against a limited company, option A checks drawn prior to the order's date should still be honored. Option B no checks drawn on the account should be paid, even if drawn prior to the date of receipt of the order. Option C only checks below rupees 5,000 may be honored. Option D the branch manager may use discretion to pay urgent checks. Correct answer is option B. No checks drawn on the account should be paid, even if drawn prior to the date of receipt of the order. Question. Where the regulations of a club, society, committee clearly covers opening of different categories of deposit accounts for each new account of a different category. Option A. Completely fresh resolution is mandatory every time. Option B. No separate resolution is necessary. A copy of the resolutions on this record is kept with a note on where the original is filed. Only head office can authorize a new account. Option D. The branch must obtain court approval. Correct answer is option B. No separate resolution is necessary. A copy of the resolutions on record is kept with a note on where the original is filed. Question. Checks payable to a club, school, society in its own name or in an office bearer's fiduciary capacity. Option A may be freely collected in the private account of the office bearers. Option B should not be collected in the private accounts of office bearers or employees of that body. Option C can be collected in a private account if endorsed by two office bearers. Option D require no special precautions at all. Correct answer is option B should not be collected in the private accounts of office bearers or employees of that body. Question. An executor derives title to administer a digit state. Option A only from a letter of administration issued by the court. Option B immediately upon the teacher's testator's death until the under the will, though probate should be obtained before exercising powers. Option C only after obtaining a succession certificate. Option D from the register of companies. Correct answer is option B. Immediately upon the testator's death under the will, though probate should be obtained before exercising powers. Question. An administrator, unlike an executor, derives title. Option A immediately upon the deceased's death under the will. Option B only from the court or letters of administrations where the deceased died intestate. Option C from a partnership deed. Option D from a power of attorney executed before death. Correct answer is option B. Only from the court or letters of administrations where the deceased died intestate. Question. Accounts of executors or administrators should be styled as option A D the state account, option B A, B and C executors or administrators of D, option C trust account of D, option D legal heirs of D. Correct answer is option B A, B and C as executors or administrators of D. Question. In the absence of any contrary directions in the probate or letters of administrations, operations on the account by executors or administrators may be done by option A only the eldest executors or administrators, option B any one of the executors or administrators without written authority from the others, option C only jointly by all of them without exception, option D none of them without a fresh court order. Correct answer is option B any one of the executors or administrators without written authority from the others. Question. An official liquidator winding up a company under court supervision must route monies received through option A, the liquidator's personal savings account. Option B, the public account of India maintained with the Reserve Bank of India. Option C, a joint account with the Register of Companies. Option D, any private bank account of choice. Correct answer is option B, the public account of India maintained with the Reserve Bank of India. Question. Before opening a current account for another bank, branches may do so at the discretions for option A, any bank, scheduled or non-scheduled, without reference to head office. Option B, other scheduled banks, including regional or rural banks. Non-scheduled banks require head office reference. Option C, only foreign banks with RBI's direct written approval. Option D, cooperative banks exclusively. Correct answer is option B. Other scheduled banks, including regional rural banks, non-scheduled banks, require head office reference. Question. A collection account opened for a company to gather remittances at various centers before transfer to its main account. Option A is an operative current account with checkbook facility. Option B is a non-operative current account. No checkbook is issued and no transactions other than remitting funds to the main account should take place. Option C must always be a savings account. Option D can be opened without any zonal office approval. Correct answer is option B is a non-operating current account. No checkbook is issued and no transactions other than remitting funds to the main account should take place. Question. As per RBI's direction, a savings deposit account should not be opened in the name of option A, an individual pensioners, option B, a minor's natural guardian, option C, a government department dependent on budgetary allocations for its functions, option D, an employee's provident fund organizations meeting IT exemption conditions. Correct answer is option C, a government department dependent on budgetary allocations for its functions. Question. Every cash payment, checks or instrument involving payment of cash of rupees 500 and above must bear. Option A, only the initials of the cancelling officers. Option B, the full signatures, not merely initials of the cancelling officers. Option C, the signature of the account holder alone. Option D, no specific requirement beyond normal processing. Correct answer is option B, the full signature, not merely initials of the cancelling officer. Question. As per the rule on second cancellation authorization, where the first cancellation is done by a special assistant, the second cancellation must be done by option A, another special assistant, option B, an officer, option C, the branch manager exclusively, option D, the same special assistant after a cooling off period. Correct answer is option B, an officer. Question. As per the signing power table for clearing and transfer vouchers, an amount above rupees 1 lakh must be signed. Option B, option A, singly by any section 1 officers. Option B, jointly by two signatories. Option C, singly by any section 2 officials. Option D, by the branch manager alone. Correct answer is option B, jointly by two signatories. Question. Vouchers relating to PL, P&L, suspense debits, sundry credits, sundry deposits, and dormant accounts must regardless of amount be option A, signed singly by any special assistant. Option B, checked and signed by two officials invariably. Option C, approved only by the general manager. Option D, exempted from any signature requirement. Correct answer is option B, checked and signed by two officials invariably. Question. Upon the death of an account holder, checks signed by him and presented for payment after notice of his death should be option A, honored if funds are sufficient. Option B, returned with the remark drawer deceased. Option C, held pending confirmations from the legal heirs. Option D, forwarded to head office for a final decision. Correct answer is option B, returned with the remark drawer deceased. Question. In settlement of deceased depositor's claim where nomination has not been made, the branch will not insist on a succession certificate from the heirs where the claim amount is up to rupees 5 lakh. Option B, up to rupees 40 lakh, provided there is no dispute among the heirs. Option C, up to rupees 1 lakh. Option D, there is no monetary threshold. A succession certificate always required. Correct answer is option B, free up to rupees 40 lakh, provided there is no dispute among the heirs. Question. For a claim amount above rupees 25,000 and up to and inclusive of rupees 5 lakh in a deceased depositor's account, the surety requirement, in addition to stamped indemnity signed by all the heirs, is option A, one or more sureties jointly of good standing for the amount involved. Option B, one or more sureties jointly of good standing for twice the amount involved. Option C, one or more sureties jointly of good standing for thrice the amount involved. Option D, no surety is required at this slab. Correct answer is option B. One or more securities jointly of good standing for twice the amount involved. Question. A succession certificate, as distinguished from letters of administrations, can be issued only in respect of option A. Any movable or immovable property including jewelry. Option B. Debts, shares or securities, not other property such as jewelry in a locker. Option C. Immovable property exclusively. Bank, bank deposits below rupees 10,000 only. Correct answer is option B. Debts, shares or securities, not other property such as jewelry in a locker. Question. An Administrator General certificate can be issued only for states not exceeding in aggregate. Option A rupees 25,000, option B rupees 50,000, option C rupees 1 lakh, option D rupees 5 lakh. Correct answer is rupees 50,000. Thank you very much for your patience. Request for like, subscribe and share.